Hi everybody, my name is Nanjia. I'm a professor of management across the street that way. I thought it's this way, but from Marshall School of Business in the Department of Management Organization. I am going to be the moderator for this wonderful panel where we'll have a very interdisciplinary sort of representation. We're going to have Professor Jennifer DIXTON and Professor Doug Moss focusing on teaching with this book. I'm going to pronounce it like the antitrust book, and that will be the first half of our discussion, and then we'll follow by Professor Ziyi from the economics department on campus and on USC campus. Ziyi teaches antitrust from an economic perspective. And we'll move on to business school. Professor Grace School from the Department of Data Science and Operations will share her teaching experience on platforms, which is very much closely related to antitrust as well. And then we'll have a discussion of sort of a very much interdisciplinary discussion when we see everybody's point. With that, let me start with Jennifer. So would you like to?
Hi, everyone. It's really nice to be here. I'm Jennifer DIXTON. Before I began teaching antitrust law and my antitrust and IP seminar, I was at DOJ for over 20 years. I left last March. So I'm a lecturer now, and I really enjoy working with the students and sort of getting to know the next generation of antitrust practitioners. It's a real treat for me, and able to share some of my practical experience too. And so I wanted to talk to you today about a few things. One is, the benefits of using an online casebook. I use the Francis and Sprigman casebook that the ABA has, our antitrust section has spearheaded and helped publish. And sort of the benefits of using that type of text over traditional text, which I have some thoughts about. And then just wanted to share some other sort of practical tips that I've gathered over the years. I've taught my seminar for about 4 years, and then antitrust law for 2 years. My last semester, I had 67 antitrust students in my class. So it's very popular at, maybe it's not a great word around here, UCLA, where I teach. I probably shouldn't say that too often, but we had 67 students, all interested in antitrust. So what are the benefits of sort of using an online text and using this text from the ABA? Well, certainly, Daniel Francis and Christopher Sprigman, put together a book that I think is just very well-rounded and timely. And I think it is so important for antitrust law today to be up to date, right? Before, antitrust law was really sleepy, right? Like when I started practicing antitrust, I think a big issue for me was whether patents created market power. That was like the big cutting edge issue that we spent a lot of time on. We talked about vertical restraints sort of being analyzed under the rule of reason. Leniency was another one, whether you could get leniency when the government already knew about your criminal conduct. So very technical issues that no one besides antitrust practitioners really cared about. You certainly didn't read about, when to get leniency in the Wall Street Journal, and that was not a thing. And today, we have the government, which has brought so many monopolization cases over the years, the last 5 years. And antitrust is really changing. It's part of, it's been a big part of political platforms, and it is totally different, I think, from when I started practicing 20 years ago. So I think it's really, really important for a casebook to be able to keep up with the time, to be able to reflect the cases that are really important. Last semester when I was teaching, the Facebook decision what came down, we were able to read about that, and market definition, which was included in the Francis and Springman casebook. So we got to see the final result of that case. We also, looked at the Google liability case, and during the semester, the remedies opinion came down. So I think an online casebook is really good at being able to respond to those updates really quickly, right? Because they publish it online, and although they don't update it, in real time, it's updated annually and it's accessible very easily once it's updated. So I think they updated in May, and you can access it as soon as it's updated. You don't have to wait for these casebook supplements and everything like that. So I think it's a dynamic book and very useful. The other thing I like about it is I think the idea of the online casebook was to make it accessible to all law students. Casebooks can be well over $300 for an antitrust casebook, right? So this casebook is free. Any law student who's a little bit interested in antitrust law and wants to dabble in antitrust can just download the book for free, and then they can if they really want to print it out, I'm one for actually looking at the book, even though I now need reading glasses, sadly. But I still print out the book, and I think it's only like $20 on Amazon, $23, something like that. So, and I'm not saying that this is the only online casebook. I've just found it very useful to me in teaching, and I think that there's benefits to it as well. Substantively, there's very good discussion questions that I think are included in the casebook that I like to use with students that really make them think about antitrust, like, should we be concerned about monopoly power if there's no exclusionary conduct? So that's like one of the questions I think that the casebook poses, and throughout the casebook, there are these discussion questions that really make you think, what are the benefits of a per se rule over a more flexible rule of reason analysis, so you can use those. So I like to incorporate, some practical thinking into the reading, and the discussion questions I think help do that. I think another benefit of this particular text to me, being an enforcer, for so many years, for 20 years, I think I'm very biased, and I think that the enforcement guidelines and all the enforcement materials are really, really important. I think they are just as important as case law. Probably, judges do not agree with us all the time. But, I think in order to have a good understanding of antitrust law, you have to know what the enforcement agencies are saying, what their priorities are, and you have to include these enforcement materials within your teaching strategy, whether it be using a casebook that includes them, or if you supplement your syllabus with these enforcement materials. And I mean things like obviously the merger guidelines, but other aspects of agency practice, like speeches, which really set forth the priorities and positions on certain issues, and I think this casebook does a nice job of excerpting particular speeches. There's one by a former criminal DAG about international cartel enforcement. There's one by Jonathan Cantor on remedies. There's one on from former AG Del Rahim on standard essential patents. So including these speeches, amicus briefs, positions on consent orders, materials like that, I think really allow students to understand sort of the policy behind enforcement policy behind antitrust law, in addition to the case law. So that's how I like to teach it. And I like that this book includes those type of materials. Just two more points before I hand things over to Doug. I think it's really great to incorporate also hypotheticals. I don't know that this casebook offers many hypotheticals, but I like to create hypotheticals for my students. I think Doug does the same, and I like his his strategy, so he's going to talk about that too. But what I do is I assign hypotheticals to the students based on the readings. And then there's a time in class where they work in groups and talk about the hypotheticals, and then the group will present their answer to the hypothetical. And then the other groups can sort of say, well, we didn't get that, or we didn't think that was, we went a different way. So it's a good way to sort of apply the material that you're learning. I've found it to be really effective. One final thing, I love to have guest speakers, not only because it makes my job easier in teaching the class that particular day, but in addition, it brings some more practical, knowledge and, a little more excitement to the classroom. We were learning about the Google case, and I had the chief of staff of the Google case come and talk to our class about working on Google, and the students just love that, right? So having that practical perspective from other practitioners and enforcers or former enforcers, I think can really supplement the antitrust learning experience and make it fun and really meaningful for the students. So those are points I wanted to make, and I will hand things over to Doug, who worked on this casebook. I think you were like one of the very first people to touch the casebook and to help with really getting it off the ground.
Well, thanks, Jennifer, and thanks, everybody. I'm Doug Ross, and I started at the Antitrust Division, although decades before Jennifer, and then moved to Seattle and practiced in a law firm for decades as an antitrust lawyer. I started teaching a little bit 15 years ago at the University of Washington, and slowly upped my teaching and reduced my litigating until about 5 years ago when I quit the litigation business altogether, and have been teaching a number of courses ever since. I teach the antitrust course, a healthcare antitrust seminar, administrative law, and on occasion, fundamentals of health law. When my son asked me what I was doing this weekend, and I should mention he's an antitrust lawyer in-house at Amazon, I said I was going to a conference called the Next Generation of Antitrust Scholars. He said, you are neither the next generation nor a scholar. And he's right on both accounts. I was a practitioner for my life, and I'm a professor from practice at the university. I have used many different casebooks, and I'm here to recommend almost all of them. I have used the Gavel Kovacic Baker book, a Rita Kaplow Edlin book, the Fox book, which is now Fox and Crane, and I used Fox and then Fox and Crane. I used another book I won't mention that I didn't like, and then I've started using the Francis and Sprigman book. And yes, I was in touch with Daniel a year and a half before it came out, and I spent a summer now 4 years ago preparing slides for the book, and then of course I taught from it that fall. Daniel taught from it at NYU, and I have used it ever since. I should mention, when I was telling a friend of mine who teaches at St. Louis University that I had used 5 casebooks in whatever it was, 8 or 9 years, he said, you mean they have somebody teaching at UW who doesn't understand sunk costs? And that is the point of having a slide deck that is part of the materials for this online book, to lower switching costs for anybody who wants to consider teaching from that book. So what's good about online? Maybe I should ask it this way. What is good about a free online casebook? And the answer, I suppose, is what don't you understand about free from the student's point of view and online? As Jennifer says, the online book is updated every year. It's very current. The book comes at antitrust law from a current perspective. There are fewer excerpts from old cases than in a number of other case books, but the old case law, which I think is important, and not just because I was there to see it happen, but it is still alluded to and discussed in this particular book. But there is a real emphasis on current events, what's happening currently, and keeping it updated. And the great thing is you can integrate the updates, right, into the text where they belong, rather than having a standalone 40-page or 60-page update that you have to figure out how to integrate for your students. So that's really good. Beyond that, it's teaching antitrust. And so I thought maybe like Jennifer, I would simply talk about how I do it, for better or for worse. And I've used the same approach in other classes, other courses, especially administrative law. But antitrust is a very current topic. Yes, it goes back in the United States to 1890. It is, and there's a huge history to antitrust. And so I say I teach it as current events, but I also do teach it as history. I find it fascinating history. And I find teaching it as history is useful for the class. It's useful for me. I didn't grow up in the US, actually. My family was Canadian. I grew up in South America, and I never took American history. And I find antitrust is a way of studying American history, obviously from a particular point of view, an industrial point of view, but the politics factor into it too. So current events and history, I use both. In the very first week of an antitrust course, no matter what book I use, I always try to make students understand how relevant this is to them. And that's easy to do, right? You talk to them about grocery stores. Do you shop at grocery stores? Well, we just had the whole Kroger Albertsons fiasco. You say, 2/3 of the class are women these days. What kind of handbags do you prefer? And there's been all this antitrust around handbags. There was the merger that the FTC stopped, but there was the crazy Birkin bag case where somebody alleged that Hermes was using tying arrangements and selling Birkin bags. And so 2/3 of the class nods at that. The other 1/3 of the class has no clue what I'm talking about. Their airline mergers, we've had several of them, including ones that matter to folks up in the Northwest, the Alaska Airlines Hawaiian merger, but JetBlue Sprint, and every student knows about Sprint Airlines. And then Amazon, which everybody buys on, and you can buy the book on for $23, as Jennifer says. So there is a ton of current stuff going on in Google and Facebook and you name it. So you get people interested in antitrust. I do use slides. I put some into maybe the materials, but I'm not going to bother showing them. The way to see them actually is go to the Antitrust Casebook website, go to the teacher materials, and Daniel or Chris can get you in there and look at the slides. If you want an updated version, feel free to contact me. I'll send you what I've got now, but they're pretty current. And so I use that. I also, this has got nothing to do with online, but I really believe in calling on students, involving students in discussion. I make it clear in my syllabus that although it's a second and third year course, you will be called on, there will be tons of discussion. And then I make that point over and over again in my classes on week one. At the end of week one, several people drop the course. They have self-selected out. That is a good thing, not a bad thing. Everybody else has self-selected in, and we have robust discussions as a result. And the folks who don't like volunteering and putting their hand up, they still know what's going to happen and that they're going to be called on and expected to talk, and they do. And the result was people actually read the material and they read it on time, which is a really difficult thing to accomplish in law school, I have learned. I do, and I think you alluded to this, Jennifer, I do incorporate problems into the course. So I have 8 problems, 1 a week, and after a couple of weeks, I have a problem every week that they write a 3 to 5 page memo on. I emphasize that in week 1 too. You have to write these memos. And a few people, you don't ever see them again. Again, they self-selected out. Everybody else knows this is going to be hard work. I won't like it. But in the evaluations at the end of the course, everyone said, a lot of people say, that was the best part of the course. It forced me to think and to write. And there isn't enough writing in law school after 1L year. So I do that. And all of those things work. I think those are the main ones. I guess I also would say if you have a sense of humor, I think you do, that's a useful thing. I don't mean that you have jokes when you say, 3 guys walk into a bar, but that you can nonetheless use humor. I find self-deprecating humor to be good. In my case, it's a target-rich environment, so I can make lots of jokes. They appreciate that. And I mix it up, I try not to have anything go on for very long in the class without a lot of student involvement, or we switch to a discussion or break into discussions, or we are always trying to do something else to keep people interested. And it has worked, and it has kept me interested in antitrust all these years on.
Hey, that's great. So, thanks so much, Jennifer and Doug. Let's take a 5-minute pause here. Anybody has any questions, particularly regarding the specific content they mentioned, especially this Francis Brickman, now I got it right, book, the case book. Let's have a discussion first. Take 5 minutes.
Hi, so Jennifer. So I actually, hi, back here. So I'm actually using the Francis Brigman book myself. I was taught out of the Potofsky book. I then was a TA out of the Gavel, Kovacic, and Baker book with various other co-authors. And I would have adopted that, but I love the fact that the Sprigman and Francis and Brigman is free. That said, I wonder, do you all use the sort of boxed syllabus? And if you don't, how do you switch it up?
I started teaching antitrust law 2 years ago, and I didn't know what to do for a syllabus, so I looked at the syllabus, and I thought it was a really good sort of guide. But what I think is really important too in the course is including some sort of specialized chapter. Like I like to include antitrust and IP because it's my expertise. I also included antitrust and AI in one of my semesters. So I think you really need to tailor the syllabus to your teaching style and also the length of your class. But I found it very, very useful that there were syllabi to look at, as a guide. Are you going to teach a 2-credit course? Here's a 2-credit syllabus. Are you going to teach a 4-credit? Here's a 4-credit syllabus. And then you can sort of tailor it to, how you want to teach the course. And then I, of course, as I mentioned, I assigned discussion questions every class and hypotheticals. So that's, in addition to the syllabus, but I found it very helpful to have something to start with. And then I had some syllabi from other professor friends that I have, but I think it was useful to also use what the casebook provided to sort of, get me thinking about how I wanted to structure my course.
Every casebook has way too much material, including this book. But I do follow most of the book. It does have special extra chapters, an IP chapter, a healthcare chapter that I wrote with a colleague. And those are good if you're going to have, say, a seminar on IP or healthcare, or you want to just substitute them into the course because they're areas of particular interest. There's a digital chapter, digital markets chapter. But I think you can take the suggested syllabus and then cut it. And over the years, the more I cut, the better I find that the teaching goes.
Did you follow it? I'm legitimately interested. I'm not just like planting questions here. Did you just follow it the first year because you hadn't yet experienced the book?
The first year, actually, Daniel was teaching at NYU. I was teaching at Washington. He was 2 weeks ahead of me. They have a semester, we have a quarter system, and we would talk every week on what happened. And in that first quarter or semester for him, he was jettisoning stuff from the syllabus, as was I, following along in his footsteps. So, and that book had big pages and small print. So you really do want to be sure not to overassign. I think you can cut a fair amount and keep the gist and keep a lot of the detail. So, you can't, you want to cover section 1, 2, and Clayton 7. I don't do RP. There's a chapter on Robinson Patman that they got Rich Stoyer from Mayor Brown formally to write because RP looked like it was going to come back to life again. And so there's an RP chapter if you want to cover Robinson Patman. But yes, I think you need to cut and prune from the syllabus to make it work. And I think, there are other people who are teaching from that book or any other book you may want to use. And if you get in touch with them and you find out they have a 3-credit course instead of a 4, do you have a shorter syllabus? Can I see that? People, at least in my experience, are always willing to share. They always think they've done something brilliant. So of course they want to show it off.
Can I just add one point? I completely agree with cutting because I think the first time I taught the course, I followed pretty closely, what had been recommended, or I had 3 credits. So I think there was a two credit example and a 4-credit example. So I created a 3-credit syllabus that I thought was, would really cover all the topics that I wanted to hit. And then in teaching the course again, I realized there were definitely places I could cut. So we could spend more time because I felt like I really, was rushing and I think, and of course, like I said, I wanted to include some hot topics in there, like antitrust and AI. So I think less is more is what I've learned.
That's great. So thanks so much. We're gonna continue with discussion. Now we're gonna branch out to economics and business. It's the multidisciplinary is Danny's signature. If you like it, all credit goes to him. If you don't like it, he will convince you otherwise. Before meeting him, I've never set my foot in this law school building, right across the street from business school. So I'm here multiple times.
Street, literally the building next door.
Across a tiny street.
Oh.
Still street. You'll see that, it's a little on the campus. So Ziyi from the economics department on USC campus, please share with us your teaching antitrust from economics perspective.
Sure. Hi, everyone. Thanks so much, Danny, for having me here today. And also today I have our department chair, Caroline, here. I also have about 7 or 8 of my students, if you want to raise your hand and say hi. They're all currently either from the Mallard program, which is Professor Danny and I run it. It's a joint master program between economics and law school, or they're from our econs master programs. And some of them are taking 1 or 2, or I think the records of 3, Junie taking 3 antitrust classes with me. So it's great to see all of them dressed up today. For the conference. All right, so let me share a little bit about my background. So I work as assistant professor of teaching at UIC Economics Department. I also work as a joint professor of law at UIUC Law School. So during my past more than 10 years of career, I spent most of my time teaching antitrust-related courses, primarily in economics department, and once a year I teach at law school, and I teaching JD students. So given most of my students are well-trained economists, they are either senior year in their undergrad or they're in the master program, and they really want to launch their career in economic consulting or this antitrust-related fields. When I design the courses, I really trying to let them see the underlying economic frameworks and why something will be considered as antitrust or anti-competitive while something is not. So when I design the course, I have 3 courses that are antitrust relevant. Usually, some of them taking them in the order, but some just taking all of them together. So the first course is when it's more like a prep course. Before they touch on antitrust, I want them to have a really solid understanding of industrial organization. And so in particular, they want to understand about all different type of market structures and all different firms' competitive behaviors. So for that course, it's more like building a library of different tools. Maybe I will giving them more than a dozen different models that will help them to, once they see antitrust issues, they can using some of the knowledge they learned to build a model and to understand it. So for that course, we started from talking about perfect competition and then monopoly. You always want to start it from the 2 extreme cases. And then for monopoly, we'll talk about some not perfect monopoly, but dominant firm, with a bunch of competitive fringe firms. And then we covered a bunch of different models in between, mostly oligopoly models. So students learned about non-cooperative oligopoly, such as Knut, Bertrand, Staggerbird competitions. They also learned about cooperative oligopoly, such as cartels and collusions. And then we also cover about merger and acquisition, so horizontal, vertical, and congruent mergers. So usually after this class, students feel really good about themselves because they see so many different models, and then they're well prepared to get into the antitrust topics. And then I have 2 antitrust directly relevant course. One is the more classical antitrust economics course. The other is a more modern economics of digital platform courses. So for my antitrust economics courses, usually I prepare students by introducing them to the US antitrust laws. And now in particular, I want them to understand what type of behaviors will be considered as Section 1, Section 2 violations of Sherman Act and Section 7 violations of Clinton Act, etc. I believe all of them who are sitting here today, if you ask them any kind of different behavior, they'll be able to pull them into the correct basket. And then I'm starting to introducing the three major categories of antitrust regulation. That is firms' unilateral behaviors and firms' joint conduct and merger and acquisitions. So for each basket, I will cover different type of behaviors. For example, for unilaterals, we talk about some of the entry deterrence behavior, raising rivals cost behavior, and predatory pricing, exclusive dealing, refusal to deal, things like that. For the joint conduct, we talk about cartels and collusions, in particular, complete cartel, incomplete cartels, and then other different forms of cartels, such as their not just price fixing, but market allocations, group boycott, and bid rankings, etc. And then merger acquisitions. For merger acquisitions, usually for horizontal mergers, I'm introducing them to different tools to figure out how they can do a merger simulation to predict what would happen post-merger using the pre-merger information. And for vertical mergers, we talk about the elimination of double marginalization, the pro-competitive side of the story. We talk about foreclosures, and we also talk about other type of vertical restraints. And for my more modern version of economics of digital platform courses, usually students by then will have a good grasp of the industrial organization topic, good grasp of the classical antitrust economics. And then I introducing them to the more fancy and up in the air topics. So for digital platforms, we started by talking about the differences between those two-sided or digital market versus the traditional market. And then we started to talk about some of the issues. For example, we using economic models, the vertical integrated models to understand self-preferencing behaviors. Now, under what circumstances firm would have incentive to treat themselves with the favorable terms than the others and why. And then we derive the market equilibrium to figure out, is that something hurting consumers, increasing prices, hurting the competitors, etc. And then we also talk about platform evaluation strategy, in particular when the firms are tying and bundling two products on the surface, or if they're not tying and bundling two products, but they're tying the underlying data together. And then for horizontal mergers, we talk about the traditional horizontal mergers, but we also cover a very interesting form, which is the killer acquisition. And that's more common for digital platform when a big GAFA firm is acquiring a small startup firms. And then for vertical mergers and congruent mergers, we talk about those pro-competitive arguments. We also talk about those foreclosure issues, which is more concerning right now. And then we also talk about something like most favored nation clause when, digital platforms are wanting them to be treated as the most favored customers and how does that will impact on the markets. So for each of the courses, I spend most of the time first talking about the economic model. So they need to be good at, figure out firms' profit maximization problem. They need to be good at deriving the market equilibrium. So how the price looks like, consumer welfare looks like. And then for each type of forms, economic frameworks I introduce, I usually will follow up with a list of cases that is applicable, and I usually take one or two to dive into as my representative case. Now, toward the end of the semesters, that's the more fun part comes. So usually I will like the students starting to work in groups, and then they'll actually need to generate an expert report. So depending on the sizes of the group, usually 3 or 4, sometimes 5 or 6 students works together. Now, they will first need to pick up antitrust cases. For GAFA, for the digital platform course, they need to pick one case against one of the GAFA firm. For the other more traditional, they can pick either a merger or cartel or other kind of abuse of dominance behavior. And then once the students pick up the case, I do ask them to gather all the literatures and the court documents. So this is more like not just to simulate the cycle of expert report, but also forcing them to read a lot of literatures and court documents. So there could be hundreds of pages of them. Now, they need to usually start it by digesting what other economists or law practitioners or econ consulting folks are talking about this case. How does the plaintiff and defendant on the court's rulings are regarding a case, and then they prepare themselves to write their own expert report and then to build their own economic analysis by applying what we learned in class. So usually the students will start it by talking about how to define a relevant market. So we covered some tools such as hypothetical monopolist test, or if they want to do a demand and supply substitution analysis and things like that. They need to talk about how the market concentration and other key features of the market, and then how does this firm's market power looks like using all the measures that we suggested in class. And then they will get to the literature review section where they have to digest how does economists or other practitioners are viewing these problems, and then who are against it, who are supporting it, and then break it down into the pro versus anti-competitive arguments and summarize it really well. And then they get to the court document section where they have to read the plaintiff's complaints, the rebuttals, the court's rulings, and then tell us what is the key battles here between them. How do they define the relevant market differently? Why the plaintiff said this is anti-competitive, but the defendant pushed back and saying this is pro-competitive. And then they started building their own economic analysis using the frameworks that we did in class. And then they will need to draw their own independent conclusions, whether they think this behavior is anti-competitive or not, and what is some limitations with your analysis. So by following this cycle, in the very end, students will need to present their works in groups, and they will need to submit their own individual expert report. So by doing this way, the students not just learn from me, for most of the semester, but they got to work on some cases from the beginning to end. And they also not just work on their own case, but they hear all the other peers who work on other cases for, a month or so to present. So they got to learn maybe a dozen of interesting cases and get into all the details about them. And also, this is a good way to train them, not just be very quantitatively prepared. As the economist major, you need to know how to do models really well, how to using data really well, but they also get to learn how to write an expert report and how to present their work. So I hope this way they got trained with their both quantitative skills and qualitative skills, and then that will, help better prepare them for today's job market. Yeah, so that's basically how I handle my antitrust courses. I'll pass it to Grace now.
Thank you, Ji.
Thank you very much. Hello, everyone. I'm Grace Gu. I'm from the Marshall School of Business. I research and teach digital platforms and technology strategy. I also, for some years, taught Python programming because I'm based in data science department. But my curriculum, the focus of my curriculum has been on case teaching, case studies of business cases, especially platform cases. So looking at the audience and our panel, I know many of you are actually experts in case teaching and also platform studies. So there are many valuable teaching practice tips that we can talk about. But I figured another option maybe is for me to talk about some of my observations of the shifts in the recent years in my classroom. So I will go with that. And there are mainly two aspects that I want to share. The first is about the relevance of cases and the Gen Z students' interest. I use a lot of classic business cases, platform cases, and there are many values to it because we can see the entire life cycle of a platform, how it grew from a small platform to a very successful, massive marketplace. So one example I love to talk about in class is the eBay case, eBay.com, the online e-commerce market. And it's a great classic example of a small niche online bookstore growing to a massive marketplace. And one day, 3 years ago, I was in class passionate about eBay strategy when one of my undergrad student, he looked genuinely confused and raised his hand saying, "Professor, with all due respect, why are we learning this ancient case?" And that was a wake-up call. To me, eBay is this really classic example where we can learn again about how platforms grow. So it is classic. To them, it is something that their parents use. So I updated my syllabus, but again, I still keep some classic cases with newer topics and platforms that the students, Gen Z students actually use. And I teach both undergrads and graduate students at MBAs, and this is particularly true with undergrads. After I updated syllabus, I see class discussion change, and it's all very lively. Now, why is this important? As we all know, case teaching and case studies has a different mindset comparing to, say, learning math or programming. Because with coding and math, there's always usually a optimized, clean answer to solve the problem. But with case study, it's all about ambiguity, trade-offs, making decisions under uncertainty. And for undergrads coming from their freshman, sophomore year, or even from high school, it's very hard for them to change this mindset. They want to, they just don't have that real life experience to understand. And they always want coding-like or programming-like type of solutions. If I put constraint X, I want to get result Y. And I found it hard to change their mindset until I updated some of the cases to the platforms they actually use and they love talking about. And I realized that they start debating among themselves and realize that their friends actually have a different perspective on the customer demands and on their understanding of the strategy of the platform. And then they start figuring out the complexity of the real world themselves without me telling them, oh, it's not like that in reality. It's much harder than you imagined. So that was a big aha moment for me and was very helpful. So that was the first observation. Second observation or aspect I wanted to talk about is something that's probably on all of our minds. That's the use of generative AI and how it affects case teaching and case studies. So in my class, of course, I have similar format as some of our panelists mentioned. I do in-class discussion. I ask the students to write reports, to do write-ups for basically each case. But then, and this is true in my class, and I saw this study by MIT Media Lab saying, and it's by Natalia Kozmina. I just want to give the credit to the author and co-authors. Saying 83.3% of ChatGPT users couldn't quote from essays they wrote minutes earlier. They ran experiments and came up with that result. And I found that to be true in my class as well. With the write-up, the students don't really remember. So one thing I started trying in the recent 2 years is I added more oral components in my teaching. And it's different from presentation. It's more of like a meeting style oral components where I ask the students to actually debate and talk about their actual strategies they wrote in the write-up. And until they start talking, did I see that they actually start understanding. And that was a big change. Last year and this year, I saw a big improvement in that aspect as well, in terms of students' understanding of the materials and their understanding of the cases. So that was helpful to me, and I thought I'd share these experiences and love to engage in conversations with the rest of the audience and panel. Thank you.
That's great. Thank you. Thank you, Grace. I really wanted to add a couple of thoughts here. One is related to the case and also Jennifer's guest speakers. And I teach product management, which is relatively new field where you don't have a lot of cover these cases, things like that. So what we do when we invite industry speakers, we ask them to create mini cases based on real work experience. So people can come in and say, hey, this is a scenario, well, all the data shows that there's a problem here. And you would students, you maybe on your own or in teams, try to relive the entire experience with the guest speaker there to provide you information such that you solve their case, and then you probably see the end of how they solved it. So the advantage of that is really new, and you have the person who was involved in the case right there. But it does require a lot more preparation. We're able to do that with our middle managers or entry-level managers. When we have a chief product manager come, the officer shows up, that's not gonna work. They'll do a fireside chat to say talk about whatever they want. And I also wanted to share some experience of the AI. It's absolutely sort of creating so many opportunities and challenges for us as educators. One of our classes, what we did was this following. So in product management world, there's one of the most important document is called product requirement document, PRD. So we ask them, create your own PRD, create an AI PRD, generate PRD using prompts. And do you want to revise? Can you give me a combined version? So that's kind of interesting to us, but then we were caught by this surprise, which I thought is really interesting to share. In theory, you have your PRD, you have AI PRD, the combined one should not be worse than either. And there are so many cases when the combined PRD is worse than human generated PRD. There are good enough cases that in their own human generated PRD that are just thrown out. And their AI PRD, our sense is that it's almost like garbage in, garbage out. You didn't really understand that. You prompted poorly. And so with that, I want to open up the floor for discussion, because there are so many interesting questions and challenges associated with teaching methods, whether it's related to antitrust or not. But let's see. What's the question? We have about 12 minutes. Yes, please go ahead.
So I have something for Grace. You brought up something very, very cool, right? This point about employing older, ancient kids, right? And I think what is so fascinating about teaching technology platforms in particular is that, you can go prior to like 1995, and there are a few notable examples of firms practicing platform strategies. You can go Microsoft, Qualcomm, telecom companies, few others. But really in a large scale, that history, Doug mentioned history, right? That began in the late 1990s. And so when you talk about some of the tactics employed by firms like eBay, we talk about PayPal giving people $20, in their accounts to kickstart adoption. I mean, those are some of the most vivid illustrations of these tactics, which then other firms have copied. So in some sense, I think you could defend it by saying, I'm taking you to the origin, right? To the early days and early choices that firms had made. And there's so much to learn from there, but I agree with you at the same time. And so those cases are much more illuminating rather than analytical or prescribing what to do, right? So you got to have a mix of something new where there is enough open to say, well, what should the firm do? But really, I think the older ones are much more from a pedagogical point of view, right? They're illuminating and illustrating.
Yes, absolutely. And thank you very much, Hemant, for mentioning this, because when I was preparing my notes, I wanted to make sure I highlight that I still use and value a lot of the classic cases, because as I mentioned, there's absolute value. And as you mentioned, we can observe the life cycle of a platform, how it flew, and what's the end result. And there are many lessons to learn, absolutely. And for the students, the cases I added, for instance, I had video game cases because they're interested in, say, PS5 2 years ago. And this year it became cloud gaming, not cloud computing, but cloud gaming. So even gaming, the context keeps changing, the technology keeps changing. So I had to update that part. But still, I always go back to Sony and their history, right? And even talk about the earliest days, like the Super Mario Brothers game, like things that are
really sounds old to them, but still there are a lot of valuable lessons to learn.
And that's very interesting, when I've used gaming console cases 10, 12 years ago, and I asked the class, how many of you are gamers, right? Console gamers. And a lot of hands would rise up. Today, they won't.
Exactly, yeah.
Yeah, you're absolutely right.
Question, yeah, Danny.
So I have an overall question for all of you. For those of us who teach, we get volunteers, and then there's the 95% of people who will not volunteer unless you force them to. What are your strategies to get more interaction without having to prod?
Okay, so I look like Doug had the initial answer.
I was with you until you said without having to try.
I know. I don't know how you do it without prodding, but if you set it up so that people understand there will be prodding and they bought into that. I mean, antitrust is an elective course. I teach administrative law, which is a required course. And so I get a little more pushback there, although it's a required course that you can take in any one of our 3 quarters. So they can drop it and self-select into somebody else. But I just insist on it, and they know that, and coming in, I think they all think it will be good for them. And going out, the comments and the evaluations all are enthusiastic about the conversation. So it's just being relentless. And there is this time, you've got a few students in class who don't participate, and when you call on them, they struggle like heck. That makes it very hard. But I just, grit my teeth and call on them anyway. So that they will get a little bit more used to it. Because I find myself in earlier years just stopping calling on people who struggle. And that's not right. It's not right for them. And it makes me feel like I'm not serving them well. So I just go head at it. I don't have a secret.
I can add on my experiences because when I teach these courses, a lot of my students are initially pretty shy. So I get a quiet classroom. And then some of the strategies I find out works really well is, well, first of all, is you take time to really get to know them. And the more they feel comfortable, they're not concerned about, getting the question wrong or so they're more willing to engage in the classroom discussion. And then another strategy is I started to work this academic year, and it so far has been successful, is to give them some bonus point for classroom participation. So when they're really active, I remember their names. I tell them you can also send me emails, get a record of when you participated, and then I can give you some bonus point. And that also works pretty effectively to have the students come to the classes regularly and then participate in discussions. And I think another way is usually I think the classroom has a mix of some. Usually for my classes, I will always have a handful of students who is really active. And then the 95 or maybe the majority of them are a little shy. I initially tried to just cold call people, but I think sometimes you're gonna stress the people that don't want to answer, and they might not end up attending the class because they're kind of feel stressed about that part. So I want to make sure this is encouraging them rather than make them feel under the pressure to answer or not. So I stopped doing that, but I do, usually when there's a handful of students who's really active at driving these conversations, and then other students started to gradually participate and more like open to the conversation. So I'm trying to, really make sure I engage in good conversation with, those students who really want to answer, encourage them to ask questions, interrupt me when they want to say some things. And then gradually the classroom does becomes more and more interactive.
That's great. Any more questions? Okay, I have 2 questions. One sad, one happier. We have time maybe for one. I'm going to start with the sad one. If it would end with sad note, that so be it. So this one is also related to AI. Actually, as last semester wraps up and new semester start, we start to have a lot of great appeals. actually in the business school. Some of them are related to this. So what happens is that if you use Gen AI to do Doug's memo or Ziyi's report or case analysis, they probably won't be as good as your best student, but they will reduce the variation. And if you assess the traditional way. So a lot of people will be actually pretty close in terms of how well they answer those questions if you let them take things at home or using a laptop. But then as a professors, instructors, we have expectation for the spread of your grades. That's a challenge, right? So I'm just curious about from the panelists and everybody else in the room, what are your ways of addressing this issue?
Well, AI is here and we, have to, students have to learn to use it, so I have a paper class, they can use it to do research and we work very closely together on their papers. So I can, tell if what they're writing, they have no idea what the substance is, and they just hand in something that was generated by ChatGPT. So I think, working closely on written product with the students, so you understand that maybe they don't understand what they're turning in, right? That's one way to do it. And then in terms of my exam classes, the first exam that I gave was completely closed book. And then my exams now are, partially open so they can bring their notes. They have no access to any online materials whatsoever. So if they, they really can't generate an essay response with ChatGPT when they don't have access to the internet.
I mean, on any thoughts in the room would be great to hear too. It's a never-ending discussion. I do include, first of all, I don't give bonus points. 20% of the grade is your oral participation. So that helps encourage it. I mean, in many business schools, it's all your grade or half your grade. So I think that's actually a pretty good model. If you're at law school, you ought to be comfortable with the idea of speaking. So I do that, and that's not ChatGPT-able. And I have oral meetings. Somebody mentioned that on these papers, you have to do a team paper once in your quarter and then come and meet with me and discuss it. So that's another opportunity. On the individual memos, they're worth very, very little. And so if somebody's writing them all through ChatGPT, they're not really going to get an advantage over anyone else. And they're not going to be learning the material, so they're going to be at a disadvantage on the final exam. And the final exam, here's an amazing thing. At our law school, except for first year and required courses, they are take it whenever you want during the exam week. And you can say you're not allowed to use the internet and all of this, but who knows what they're doing. I don't like that. And required courses you can insist be done in a classroom at a certain time. I do that for the required courses I teach. I'll say this, for the antitrust course I just taught this past quarter, nobody used ChatGPT for the exam, and I'm just, impressed by that. I impressed on them over and over again not to, and but it happens. I know it happens talking to all sorts of other people. It happened to me on an earlier admin law course. It's unless you proctor it, I'm not sure what you do.
Yeah, I can share some of my experiences. So generally speaking, my students are not allowed to using AI tool to help them with the main part of the work. They cannot using AI for exams. It's a closed book in-class exam. Like it's based on the models I taught them. So AI is not going to help much anyways. For the final report, I mean, literature, AI is not going to help you summarize the literature correctly. It's just, I tried myself. It's giving you the wrong information, even the wrong references, right? They made up some literature that's not exist. Same thing, the AI is not going to help you summarize the court documents in the ways that I want you to break down into the contradicting and battlegrounds between different sides. And AI is not gonna help you much with the economic analysis. So I think I sort of designed the courses in the way that AI is not gonna really replacing your work, that you still have to put on your own work to do the stuff. But in the end, if they're using AI to help them, gather some initial documents, polish their grammar of their paper, I'm fine with that. It just is not gonna really used for other main part of the assessments. And I do have my TAs and graders using all different kind of software to detect if this is a paper that's being generated by AI. And I did warn them if we find out like your paper is suspicious, and then you might fail the course. So they're like a little more cautious as well.
Could I just say one more thing? So this morning I asked AI when I was at the airport in Seattle, I have a business class ticket. Can I use the Alaska Lounge? And it says, yes, you can. And it goes on and tells me all the great amenities of the lounge. In summer, you should be able to enjoy the Alaska Lounge before your flight to LA. Have fun. I go to the Alaska Lounge. No, sorry. You can't use it with your ticket. You need a membership. So there's AI does make some mistakes.
Definitely. All right, okay, on that challenging but promising note, thank you so much for staying with us for extra 2 minutes, and I look forward to having this continued discussion during the break. There's no break, right? You guys go directly to the next one?
No, we're going straight into the next program.
All right, let's give our panelists a round of applause.